Dre, one of the biggest issues that our clients face, even if we completely exonerate them, is what the heck to do if they've been titled by CID for an offense. And what titling means is they're in the title block of the investigation. And if that happens, it gets reported to the Criminal Records Center, and they now have a criminal record that shows that they've been arrested and were under investigation for whatever the offense was. So employers who do a background check, professional organizations like a bar association or doctors associations or the Federal Aviation Administration do background checks. This pops up and it affects their ability to get jobs, to get schooling and higher education, and even join some of these professional organizations. Have you had that problem?
Yeah, I have. And in past years, especially the CID or the MPs or the police authorities in the military in general, kind of took that decision really lightly, that these decisions can have lifetime effects like you're talking about. It's like you were arrested. Whether or not you were put in handcuffs or not, you are in the title block of the investigation. So it's basically like going to go into a database that the FBI, local police departments all have access to, and it'll follow you for a lifetime.
Right, and let's face it, these titling decisions are such a low threshold. It only, the investigator only has to determine that there's credible information that you committed an offense. And credible information is below probable cause, it's below reasonable suspicion. It's just a low standard that they think, there is information that you may have done this, and they get you titled. And you don't really have a response. Up until recently, the only way you could reverse a titling decision is if you're able to go in and prove that at the time the titling decision was made, that there were facts that were not considered, that were available to that investigator, that they should have considered, that would have changed the titling decision. In essence, you can't really change it.
Right. And like I said, in years past when I handled these type of cases, they acted like it was just like moving mountains to untitle someone, even though the evidence was really clear that this was the wrong decision. My client should not be titled, but they wouldn't untitle him.
Right. Well, thank goodness that's changed. There's a DoD instruction. It's instruction 550507. And what that instruction now says is that there are 3 instances when you can get your titling and indexing expunged. The first instance is if there's no probable cause that the offense occurred. The second is if there's no probable cause that you or your client committed the offense. And the third, which is really difficult to understand, is in the interest of justice. And they don't define what the interest of justice is. But in those 3 instances, you can now, since August 3rd of 2023, go and get your record expunged. And that's a huge change.
No, it is. This is why it's so important to bring us in early, because if we can stop a case at the titling decision level to save the client the pain and suffering of going, through an administrative process or a court-martial or whatever it might be, now we can make the arguments at the ground level at the titling decision.
Well, it's always true. The sooner you get somebody who knows a lot about justice into your case, the more options you have. Right? As time goes on, those options seem to close. But this new DoD instruction, 5505.07, is a game changer. I've talked to many CID agents over the last couple of weeks, some supervisory special agents. Nobody knows about this, right? So it's kind of flown under the radar. It was DoD IG is the proponent for the change, probably because they got so many doggone complaints about titling. But in this instruction, it also tells the expungement authority that you have to consider other things. You have to consider whether or not there's corroborating evidence for the offense, whether or not there was any administrative actions taken against the individual, and what those administrative actions were. And you take all those factors into consideration in the interest of justice. And now, a lot of people who just had the door slammed shut on titling have that door wide open where they can they can get relief.
Right. And the different service branches are going to take a while to figure this out, exactly what this means.
Right.
So that's why it's also important to bring us in so we can convince the individual service branches what this DoD instruction actually means and what its purpose is for, and our client gets treated fairly.
Right. This change was in August of 2023. Today it's February 2024, and none of the services have made any attempts to implement this DoD instruction. So it's just sitting out there without branch implementation. So that's a good reason to get us involved, because you absolutely, if you've been titled and there's no probable cause, that needs to come off your record.
Absolutely.
We're the law office of William Helixson, and I'm the warrior advocate. You defend the nation. We defend you.